and the protection of intellectual property. And once again, I welcome each one of you, and I hope this will have a fruitful and enjoyable experience in this webinar. Over with you, Simi ma'am.
Thank you, Shweta ji, and good evening, everyone. I'm so glad that I have been invited to discuss about the WIPO and IPR laws in India. As we all know that it's a very vast topic. So with the 1 hour time constraint that I'm given, I'll be doing a surface browsing through, going over through what is WIPO and how the intellectual property rights have been introduced in India, its timeline, and the different kind of acts that has been developed under the IPR laws, and a brief overview of the Patent Act. So any questions that is there, I will be happy to answer towards the end of the session, or you can even go through KAMRA Associates and send your queries, which can be answered at a later stage. Thank you so much. With that, I'll start off with the WIPO. So WIPO or WIPO, whatever we call it, it's known as World Intellectual Property Right, which is a global forum for the intellectual property services, policy, information, and cooperation. Now, the term intellectual itself confirms that it is something which is brought about to protect the creation of the mind, someone's creation of the mind, right? So we think of ideas, and ideas, how can these be protected? Because if a person brings about the idea of some process, and they want to protect it. Earlier, there were no laws, so somebody could copy it, somebody could infringe them. So to protect their rights, where somebody cannot recreate these things without their permission, or somebody cannot exploit it commercially, we have these intellectual property rights that was introduced. So the WIPO was established in 1967 with its headquarters in Geneva, Switzerland, and it has 193 member states, and India is one among them. Now, the member states, how do they become member states? They have to submit an instrument of ratification or accession to the Director General, and they have to be a member of any one of the conventions like the Paris Union, Bern Union, or the United Nations, or they have to be a party to the statute of the International Court of Justice. Else they have to be invited by the Director General to become a member of the state organization. Now, WIPO has already administered 26 treaties, which includes WIPO Convention. A few of the treaties, main treaties that I would be going through is Paris Convention, Bern Convention, Vienna Agreement, and finally...
Sorry for interruption, ma'am. Actually, someone is saying in chat box that you are not audible to him. Everybody, ma'am is audible for you, all of you, or not?
Yeah, she's audible.
Yes, ma'am. Ma'am is audible.
Okay.
She's audible.
So might be in your laptop, there is any issue in audio. So kindly check your audio setting. I think so. That's why she's not audible to you. Okay, ma'am, start, ma'am. Thank you so much.
Okay. So yeah, basically I was telling that I will be discussing about the Paris Convention, the Bern Convention, the Budapest Treaty, Madrid Agreement, Vienna Agreement, and the TRIPS. Okay, TRIPS is the game changer that brought about a lot of changes in the IPR laws in India as well, because now we have ratified with that and we have made amendments to our different IPR laws to comply with the TRIPS regulations. So basically, Paris Convention, which was concluded in 1883, brought about the laws in for the Patent Act, the trademarks, the industrial designs, utility models, service marks, trade names, geographical indications, and the representation or repression of unfair competition. Now, what are patents? Patents are given for inventions, whereas trademarks are like where you have a logo and that belongs to a particular entity. and this entity being represented by the authorized people. Now, utility models, again, these are of the industrial application, and service marks, trade names again, and industrial designs. So the designs, it can be made in some other country, and if it is integrated with a product which is made in another country, that doesn't mean that it doesn't get a recognition in the country where it was collaborated with the product. So the product as a whole, when for example, now you have a car which is maybe manufactured in India, but then you are bringing one of its accessories from outside, which is ergonomically designed, say from Japan or Korea, and then you are putting it into that car. Here what happens is the industrial design has to be recognized. According to the Paris Convention, it has to be recognized in the country that it was installed in. They cannot say that because it was produced in Japan, because it was produced in Korea, no, you wouldn't get a specific license or a sole license to it. Then it ensures that the intellectual works by creators are protected in other countries. So basically, Paris Convention, it has three principles or three categories that it brought about. One is the national agreement. Now, what do we mean by national agreement is that equal protection is given to all the persons or the inventors. Because see, if I am in India, I am creating something and I am applying for a patentship in, say, abroad. Okay, so if it is a member state of WIPO, then it has to give me or recognize my patentship. When I file for it, they cannot reject it there. So they have to give an equal protection to whatever my invention is. Similarly, what about non-nationals or that country where they are not member state to WIPO? Still, their invention has to be protected. So this is known as national agreement. Whatever recognition you are giving to a national in your country, you have to give the same recognition to the national of the member state as well as the non-member state, the invention. Then right of priority. So that means that when there is a filing that is done in my country and then abroad I go ahead and I file something, I have a priority than anyone else who has brought about the same invention. And this priority, again, we cannot have it for like lifelong or for an indefinite period, because then that would give constraints to people who would like to bring about more inventions, probably enhanced ones. So there is a limitation that is given to this. Now 12 months is given to the patents and utility models, and 6 months for the industrial designs and marks. Then comes the common rules. There are some common rules that the member states need to go by. Now, these common rules are a few of them, which I would explain here, is like patents. Patents granted in the contracting states for the same invention are independent of each other. That means if I have invented something and some other person has invented in some other country, that doesn't mean that I cannot be granted patentship. Both of them can be granted patentship according to their national laws. At the same time, if my patentship was rejected, that doesn't mean that that country has to refuse their nationals patentship. So that person has all the right to go ahead and file for the patentship. And then there are certain conditions like, compulsory license. I can see that somebody has raised their hand, Galaxy 31. Is he asking something or?
No, actually it's from beginning, ma'am. Hand was raising from beginning.
Okay.
You carry on, ma'am.
Okay, so now this is where the compulsory licenses were also introduced. What is compulsory license? This is what we need to understand. Compulsory license means if somebody is given a patentship and they are not working according to the mark that they promised or according to the specifications that they delivered, or even to that extent that the particular product or process that they have brought about can be made at a reasonable rate than what they are giving it for, then in such a condition, the license can be given to the other person or entity who is producing it, or who can introduce the process in a better manner at a very subsidized rate. I'll be giving you case laws where these kind of things have happened in India. So going ahead, then we come to the marks, because we have, everyone understand that marks which are like, we say that it's a trademark mark. Okay, for example, like Adidas or Pepsi, they have their logos or things like that. So there is no particular hard and fast rule for the filing and registration of these marks, but this is recognized by the domestic laws in those particular nations, which are the member states. They can lay down the laws regarding the regulation of the marks. Now, collective marks need to be granted protection. So this is like, for industrial designs. Industrial designs must be protected in each and every contracting state, and the protection cannot be forfeited, saying that the design was not incorporated in another particular state. Okay. Similarly, trademarks, protection must be granted to the trademarks as well in the contracting state without, an obligation to file or register names, because these are like very creative things and which have been there in existence from the beginning, and such things needn't be filed. Even if it is not filed and they come ahead and say that, no, this was our mark. And if that mark has been in use for a long time, so it gives them all the protection, even if some other person comes up with a similar mark telling that I had brought this about and I need a license. So these are few of the things about the Paris Convention. Now, going ahead with the Berne Convention, which was finalized in 1886 and it was amended finally in 1979. The Berne Convention was brought about to protect the work of certain and the rights of certain authors. Now, who are these authors? Musicians, poets, painters, and such people, to control who used their work, and they had to have permission to reproduce it. Now, the three basic principles that the Berne Convention was based was national treatment, automatic protection, and independence of the protection. Then it also focused on the moral rights. The time period for the protection was 50 years from the date of the work, or 50 years from the death of that author. Now, this was applied for everything else except for applied art and photographic works, which had a minimum of 25 years of protection. With that, we go to the global protection system. Now, the Budapest Treaty was also administered by WIPO, and it was concluded in 1977. Now, what the Budapest Treaty was brought about was for microorganisms. Now, microorganisms, what we have to understand is it is available in a particular locality or a particular country, and it cannot be transfer to each and every country for licensing. Once it has been invented, what option Budapest Treaty kept forth is that they can file it in an international repository system. So basically what happens is that there will be a depository which will be observed by some authorities, which are again member states, and they will be taking care of this. Earlier, there was nothing to deposit these microorganisms or file for a patentship for this. But with this Budapest Treaty that came ahead, And then the International Depository Authority was formed, which is basically known as culture collection. And there are 49 authorities as of, that is, on January 26, 2023, we have 49 member states who are the observers of this depository. Then we come to the Madrid Agreement, which was finalized in 1891, and it was for the international registration of marks. This is how, then again, what happens is filing needs to be done only one time. They don't have to go to each member state and file for the recognition of this mark, but there is an international registry where they will keep this mark and give recognition to those marks. Then we have something called the classification WIPO. So under here, the major ones are the Vienna Agreement. Vienna Agreement was concluded in 1973 and it was amended in 1985. Now, this protects marks consisting of figurative elements. Okay. We'll come to this in details later on. Then comes the TRIPS, which was the final agreement. As I mentioned earlier, this was a game changer for many member states because the TRIPS brought about a lot of regulations regarding the patent, the industrial design, the marks, the trademarks, and the plant varieties. It brought about lots of regulations. So this is known as a complete multilateral agreement. With that, let us step into the Indian IPR laws and WIPO. So in India, the IPR laws was like introduced in way in 1800s, but the exact existence of the same or the understanding came in 1975. We even have a specific website completely explaining about the IPR acts and the rules and regulations concerned with it, as well as how do you have to go about filing it and who can file it. And now they have introduced e-filing as well. So here also the IP offices are not available across like India, but in selected states. So copyright offices is in New Delhi, where the Office of the Controller of General of Patents, Designs and Trademarks is there. And then the industrial property offices exist in Mumbai. And the trademark registry at Mumbai, it has branches in Kolkata, Chennai, Ahmedabad, and New Delhi. Now, there's a recent office that was opened, Geographical Indications Registry, which is established in Chennai. So these are the offices where you can file an application if somebody wants to file an application. Now, who can file an application and who will be protected under this? All this will be coming in the later stage. Now, how do we know where does IPR law have its origin from? Like, is it somewhere in the Constitution? Is it mentioned somewhere in the Constitution? Yes, it is mentioned in our Indian Constitution, entry 49 of list 1 under the 7th schedule. Now, these IPR laws can be protected both in a civil manner and criminal manner, but the only criminal remedies are given in both Trademark Act and Copyright Act. So with that, let us have a walk into the history of the timeline of the various acts. Now, Patents Act was introduced in 1911 as Indian Patent and Design Act. However, it was renamed as Patents Act 1970 in 1972. And the final amendment, after a lot of amendments, the final amendment was made in 2005. As I mentioned, I'll be giving a brief overview of the Patents Act at the end of the presentation. Now, end of this webinar, yeah. So, The Trademarks Act was introduced in 1958 as Trade and Merchandise Marks Act, which later on went to be renamed as Trademarks Act 1999, which complied with the Madrid Protocol. Okay, then we have the Copyright Act. So basically, we have like 7 acts under our IPR laws. That is, those are those that protect the inventors or the creators of a content. Now, Copyright Act has one such act. 1950. It was introduced in 1957. Now, the Copyright Act, as you know, gives protection to content creators or those creative ideas which cannot be reproduced unless you have a permission for that. These can be audiovisual contents, songs, movies, etc. Now, Industrial Designs Act. This was introduced in 2000. Industrial designs means those machineries or ergonomically produced parts or something. So they have specific. Now, if you look at a car, for example, we select a car with its design, with its, the seating capacity, how the seats are designed. So if you look at Mercedes-Benz, they have a specific design which cannot be copied by any other vehicle manufacturer. Similarly, every other vehicle manufacturer has this kind of thing. Recently, we know that Toyota and Maruti company, they merged, and they Toyota allowed Maruti to sell off some of their cars. So here, what has happened is, since they merged, they got a permission, they can sell that car. So they have a protection. Okay. Otherwise, these industrial designs are protected under the 2000 Act. Now, geographical indications. What do we mean by geographical indications? There are certain items which belong to a particular state, even across India. So like, for example, in Kerala, we have something called as Arammula mirror. Arammula mirror is made of 5 different types of metals. So Panchloha, that's what we call it. So what happens is that is designed by those particular craftsmen, and to recognize that they have a protection under the Geographical Indications Act, which was introduced in 1999. Now comes the plant varieties, which is also known as the Plant Act, Protection of Plant Varieties and Farmers Act, which was introduced in 2001. Then comes the layout designs of integrated circuits. Now, circuit boards, everyone has seen, especially for, like, say, our computer systems. There are different ways that the circuit boards are laid out. Even that design can be protected. Nobody else can copy that particular design. So this comes under the Semiconductor Integrated Circuits Layout Design Act, which was effected in 2000. Then remains. With that, we come to the Patents Act 1970. So basically, as I promised, I'll have a brief overview of this today. Since this is a very large topic, we look forward to doing a series of this so that we get a proper understanding of what each act brings about and how each act protects someone, and what are the remedies, legal remedies, in the event that we have been infringed of our intellectual property rights. So Section 3 and Section 4 of the Patents Act gives us a whole list of things what cannot be patentable in India. So basically, the whole point is it must be an invention. Now, invention has been again defined in the Patents Act itself. Invention and discovery, these are two words sometimes, people swap. But in actual, discovery means something which was existing and we found it. Nobody else found it, but we came across it. So that's not an invention. Invention is something which nobody had found or neither existed. So that is what we need to understand. It should not be mere discovery. So that's the first thing. Mere discovery is not considered as an invention. Second, it should not be frivolous or contrary to the natural laws. Third, it should not go against public morality. Sorry, was someone asking something? Okay, I'll continue. Okay. Then it says, section 3 says that mere admixture. Now, admixture means I have mixed two metals. I got an alloy, but the alloy is still showing the characteristics of the metals that's existing in it. So it cannot be an invention. Similarly, even say for fertilizers, we mix something and then we say that, oh, this is a new fertilizer that I invented because I mixed a part of this fertilizer and part of that fertilizer, and now it is a new product. No, it cannot be a new product because it is going to it doesn't bring about any enhancement. Had it brought about any enhancement, then it can be said that, okay, this is a new product that has come about and this can be patented. But if it is showing the characteristics only of that was whatever was mixed, then it cannot be an invention. Similarly, horticulture or agriculture methods cannot be patented. Now, why do we say that? Because if that is to be patented, it will be a major blow to our agriculture industry, because agriculture is one of India's basic field that we depend upon, or the economy depends upon. And if somebody gets to monopolize it, there will be a lot of drawbacks. Similarly, medical or curative methods that is done both on humans as well as on animals cannot be patented. As said earlier, it is very relatable, because if somebody monopolizes it and says that, okay, this is the way that I have, for example, there is an operation or a surgery done on a person, and there is a method of stitching that, okay, one of the doctors is doing, and then they say that, okay, this is only my method of sewing it up or putting a suture, so you cannot do the same thing, or you cannot follow the same thing. Then what happens there is that it's getting monopolized and everyone will have to approach this doctor. Similarly, making of medicines as well, if there is a better better way or enhanced way, but at a subsidized rate, as mentioned earlier, then that particular company or a firm or medical organization can be given a chance to get a license to patent it. A similar thing goes for essential biological processes. Those cannot be patented, as well as simple mathematical or business or computer programs or aesthetic creations or any mental act. For example, we are playing chess. And what happens is, in chess, what do? Like, we are using our mental creativity or our mind to make those moments. And if we say that, no, I want a patentship for this movement that I made, or move which I made, so that restricts the others from using those same things. So these kind of things can arise in anybody else's mind. So these cannot be patented as well. Then a way of presenting information, for example, the presentation that I'm doing now, or the way that I have organized or laid out, okay, this is how I'm going to speak today. And the same thing, okay, I'm going to do a PPT presentation, or I'll give a handout today. And I say that, no, I need a patentship for this because this is my method of, presenting things. No, that can also not happen, because these kind of similar things, yes, people can reproduce, or they can think on their own and bring forth, and this cannot be patented. Similarly, topography of information. Topography of information is the way in which the information is placed. For example, I did mention that, there is a protection under the semiconductor or integrated circuits, but at the same time, the layout cannot be patented, because anybody can follow a similar layout, but they must have a different purpose or different mechanism for the semiconductor or the integrated circuit. It must not be the same thing. It must be in the same way that the other inventor has invented. So the layout cannot be patented. Now, traditional knowledge, for example, we all know that being Indians, we know that how turmeric is medicinal value. And if somebody wants to patent it, then they cannot do that because it is already a non-fact for time immemorial, like, from long time. It's been known to everyone, and there are similar instances where the US had tried to patent like turmeric or neem. So these kind of things, these are like long known fact that they can be used for like traditional medicines. Hence, this cannot be patented. Similarly, Section 4 says about atomic energy inventions which cannot be patented. Now, who is protected under Patents Act 1970? Of course, the patent owner. It gives the right to the patent owner to stop others from commercially exploiting the patented invention. Now, when I say patent owner is protected under Patents Act, there is one more thing that the patent owner needs to keep in mind. If it is brought in the public domain, then no, it cannot be given any sort of protection, because even before filing, it has been brought into the public domain. Again, there is an exception which we will come to it later. Now, what can be patented? So any invention relating to a product or process that is new, involving inventive step and capable of industrial application. These are the three things that needs to be kept in mind. It should be a new product or a new process, as discussed earlier, and then it should involve an inventive step, but the most important thing is it should have an industrial application. Now, ever since this was introduced, the Patent Act 1970, what was the amendment that was brought about in 1999? Now, the amendment that was brought about in 1999 was Section 5, Clause 2, where filing of applications for patents in the field of drugs, medicines, and agrochemicals was introduced. And there arose the concept known as mailbox concept. The mailbox concept is from TRIPS. Okay, so basically, the trade related intellectual property agreement, what it said is that if somebody has invented something, unless that particular nation has a domestic law to regulate it, they can keep it, store it, okay, till such law is brought about. And when that law is brought about, the first person or the entity who has applied for the patentship will be granted the patentship. Similarly, EMR was introduced, exclusive marketing rights, through Chapter 4A. Now, exclusive marketing rights means that only the patent owner had the right to market it, but in the future, like, it was taken away. Now, Section 39 was also omitted. Section 39 was that they had to file in India first, or any member state, that particular citizen of that state, they have to file it in that particular country before filing it anywhere else. This was taken away. But in 2003, this was reintroduced. So they needed prior permission, or they had to file in their own country first before going to any other foreign country for a filing system. Okay. And then the term of patent was only 14 years, which has been extended to 20 years in 2003 from the date of filing of complete specification. Now, speaking about complete specification, when we are filing for a patent in the initial stages, yes, I have an idea and I want to protect it, but I haven't come to the complete idea. My idea is just vague and it is halfway, but I know that I can make this idea work out. In such situations, we are allowed to file a provisional specification, but within a period of 12 months, we should give a complete specification and apply for examination. So what is applying for examination is that we have to say that, okay, our product is ready. I can see hand raised.
Ma'am, actually, one message is in box. Kindly read that and please reply.
Okay. Actually, like I can't see anything here. Am I allowed to see or?
Ma'am, actually, chat is open for every person.
Okay, but my meeting chat is.
I don't think so.
I can't see that. Can you just tell me what the message is exactly?
Just a minute, ma'am. Don't know what is the issue. Ma'am, actually, message was that, ma'am, what is the difference between trademark and property mark?
Okay, I shall answer that towards the end of the seminar, because I'll complete with the patents, okay, and then I shall answer the questions.
Okay.
Yeah.
In last 10 minutes.
Yeah, sure.
Thank
So
you.
any questions that come up, you may just note it, and because I cannot see anything here on my chat box as such, but you can note it and then later let me know.
Yeah, agreed, ma'am. Thank you. Agreed.
Okay. So, yeah, I was telling about the examination system where we have to apply and tell that, okay, my product is ready and you can come and examine it. And then they come to check out how your product is working. Is it working according to the specifications that you mentioned? And during that filing, they are going to check that is there any other idea which was already patented or for which an application has been filed already. In such instances, what they do is they go through a check. They have a registry where they have all these things mentioned, and they go through that registry to ensure that there was no application that was filed prior to this. Now, in 2003, again, what has happened is publication of applications after 18 months from the date of filing was introduced, and also microorganisms became patentable during that year. Now, Section 39 was reintroduced, which I mentioned earlier, and there was the provision of appellate board, which was not there earlier. That was also introduced in 2003. Earlier, the Controller General of Patent makes the decisions, and that was final. But then an appellate board was introduced. So anyone who felt that the decision of the Controller General was not making them happy, they can always approach through an appeal to the appellate board. Similarly, polar exception. As I mentioned earlier, the rights of a patent owner cannot be protected if it is put on public domain. But in polar exception, it says that there is certain elements they can use the product, they can exploit it commercially. The patent owner, I'm discussing about the patent owner, they can bring it out into the commercial market before they can confirm that their specific product is doing the intended job that it should do. So whatever specifications they have applied, they can try it out. So that's, like we say that that's just a sample product or like that. So these kind of things, even if they are in the public domain, what happens is that it can be protected under the Patents Act. Now, in 2005, what was the amendment that was brought about? Section 5 was deleted totally, and that is where the product patent regime came in India. And then abolition of EMR was also done. The exclusive marketing rights were taken away. Now, few cases that can be discussed are some landmark cases. One is Bajaj Auto versus TVS Motor Corporation. This is a 2010 case which was in Madras High Court. Later on, Supreme Court had also involved. And this is one major case also. Though there were only observations made by the Supreme Court, the thing is that This is one case which led to the idea that any case related to patentship or IPR law under IPR laws came in, this should be looked into and completed within 4 months period. So a judgment shall be passed within 4 months time. So Bajaj Auto Limited versus TVS Motors company. Here, what happened is that Bajaj Auto had told that their patented DTSI technology or the twin spark plug technology shall not be used by TVS Motors because it solely belonged to their design, and that was the main feature of their design. So here, doctrine of pith and marrow was used, or it is also known as doctrine of equivalence. Similarly, Novartis versus Union of India, a 2013 case which came to the Supreme Court. Here, a drug called Gleevec, which was an already existing form of drug known way back in 1993. Novartis claimed that they invented this. However, that was not the case and it was rejected. So as mentioned earlier, mere discovery is not considered as an invention. Then another landmark case is Bayer Corporation versus Union of India. Here, cancer medicine known as Nexavar was produced by Bayer Corporation, but the value of that money, the amount that they put, the market value that they put for this particular medicine was too high that it couldn't be afforded by a normal person. So another company called Natco Pharma came forward and they produced the same medicine at a very, very reasonable rate, which could be made affordable to any layman. And they were advised to give a royalty to Bayer and to even try to give it out as free medicine to people. So these are the basic things of Patents Act. There's more to it. But for today, I think it's already like 5:45. So I'm ready to take questions, if any.
I mean, chat box, there are questions like, ma'am, what is difference between in trademark and property mark? By Vaishnavi.
Okay. So the trademark is the represents the manufacturer. For example, as I told you earlier, it's like, Adidas or Pepsi, that's a logo, right? You cannot use that. It's their trademark. They are trading under that logo or that name. But property mark denotes the ownership of a particular property. Is that clear?
Are you there, Vaishnavi, ma'am? Kindly give revert of Simi, ma'am. Anyways, leave. Next is ma'am, Mr. Prakash Kumar. Madam, is it true that geographical indication tag sparks a bitter debate on Rasgulla? How such cases are dealt with 2% state claim on GI tag?
Okay. Yes, it sparks a debate because we know that Kolkata is one place where which claims, or Bengal is one place which claims that Rasgulla belongs to them, and Odisha also. Basically, since I am from Kerala, I don't know like where does this Rasgulla originate from.
I think it's from Bengal. Bengali dish na Rasgulla.
Yeah, as far as I know, that is what my friends used to say, Rasgulla. So yes, but I think Odisha also has a history of like Rasgulla.
Okay.
So finally, they have got that GI tag. That's what I understand.
No, it's from Odisha, Roshogola.
Okay.
Some,
Okay, I'm not debating on that because I'm a person who doesn't know where it originated from, though I'm a
yes,
foodie.
yes, 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 yes. No, okay, continue, ma'am.
Okay. So I think that's it. And I was hoping people would be having questions which I shall answer. Otherwise, there are a few things about Patents Act only. It's basically who can file. It's not the patent owner alone. There can be a authorized representing agent who can file these things. And as mentioned, filing can be done first a provisional specification can be given, and a small description of whatever you have intended to make and how it is going to work needs to be given. But within from that time, you have a period of a year, wherein you have to file the exact specifications, or known as the complete specifications. Do you have a question?
What is the scope of this law?
A very nice question. Scope of this law, because in today's world, I think, see, people are advanced, and they have a lot of creativity. So what happens is, it helps to bring out more creative inventions, and that is what we need in today's world to make life easier. At the same time, if some inventions can be made in such manner that even layman can afford it, even a person with an average salary or below average salary can afford it, in such cases this law is very welcomed in this era.
Thank you, ma'am. Kindly speak kindly ask your queries to Simi, ma'am. Don't write in chat box, because actually in chat box was unable for Simi, ma'am. So please ask your queries by speaking. लगता कोई है नहीं.
See, if anybody has any query, definitely if they don't want it to ask over here, and certainly you can ask through KAMRA Associates, and they can reach out to me. You can reach out to me, and then you can later reply to their queries.
Guys, kindly turn on your cameras, please, because Mr. Raj Yadav, yes, ma'am. Raj Yadav, kindly speak, please. Kindly ask your query to ma'am.
I have a request. Ashwin Gaonkar would like to control your camera. Is it something that I have to approve or decline? I don't know. Am I audible?
Yes, ma'am.
Yeah, I got a request, somebody would like to control my camera. Am I supposed to approve it or decline it? I don't know.
Ma'am, decline it.
Okay.
Is there any query of any person? Can I know the career opportunities of this field of law?
Okay. The career opportunities in the field of law, you mean in IPR, is it? Can they make it, can they specify?
In IPR.
Okay. See, you can be legal advisors of organizations or companies or entities, business entities. Okay, you can become an IP lawyer, and that is a very good option. And it's trending here. Recently, our office had a case which was related to trademark, and that came in news and everything. It was regarding like two brothers who were running a hotel business, and one of the brother had already taken a license for keeping his trademark, and the other brother went ahead and opened up another concern saying that this is a sister concern, and then they had a fight, and finally the person who had already got the license won. And yes, so basically yes, you can become an IP lawyer. That's a very good career option.
Can I ask my question?
Sure.
Ma'am, I have a question. Is online business and offline shops come under intellectual property right? There is a debate on online shopping app like Flipkart, Amazon, who जो कि मतलब ग्रोसरी वगैरह भी प्रोवाइड करते हैं, और कुछ जो शॉप्स ऑफलाइन होते हैं, लाइक जो शॉप्स हो गए या फिर गारमेंट्स के शॉप हो गए, is the claim for intellectual property right?
Certainly that will come under the intellectual property rights, but provided whatever conditions that I mentioned. See, it should be a novel invention. It cannot be anything that was existing and then they can say that, no, I need to have a right over it.
Like patent, like turmeric patent, and it is a long-term known patent. No one can claim for turmeric and neem, like this type of online shop and offline shops like is that.
True, unless there was a condition for that also. If it is an enhanced product,
yes,
I hope you understand, it should give us too many benefits, then only it becomes an invention, right?
Yes, ma'am. Like necessity is the mother of invention. If a person got so much knowledge and things from, then we can claim for intellectual property right.
Certainly we can.
Thank you, ma'am.
You're welcome. I liked her spirit. She was so active, so energetic.
I was also happy that one person actually speaks. Every person is silent. Every people are silent.
When you people ask, it challenges me, because then I start thinking as well, because there must be some people who have a lot of doubts, who have a lot of queries, which I might not have thought of in that line.
Ma'am, do you speak in Hindi also?
I do speak in Hindi.
फिर थोड़ी सी बात हिंदी में कर लो, अच्छी बात, अच्छा लगता है, अपनी लैंग्वेज है, वो भी मदर टंग है ना, इसलिए.
Yeah, but I do speak Hindi, but I don't want to speak in Hindi because I think my Hindi is not like anywhere near yours.
No problem, ma'am, सिखा देंगे.
But I do totally understand Hindi because I was in CBSE syllabus and I was doing Hindi, so
आपसे हमें इंग्लिश सीखने को मिलेगा और आपको हमसे हिंदी सीखने का मौका मिलेगा, है ना? कुछ ना कुछ सीखने का तो मौका मिलता है यार किसी से.
वो तो सही है.
क्या बात है, बड़ा अच्छा लगा. मैम, एक बार सभी को एक रिक्वेस्ट है, प्लीज टर्न ऑन कैमरास, एक स्क्रीनशॉट ले जाए ताकि वो हमारा फिर आगे डाला जाएगा उसको गूगल पेज के ऊपर. काइंडली प्लीज सभी. श्वेता मैम.
1 second.
हाँ जी, प्लीज.
कैमरा हाँ कर रखा है कैमरा उनका.
सॉरी.
Yes, thank you.
Okay, now Shweta ma'am, your speech please, last. We have to wind up now.
Sir, someone is asking a question.
जी बताइए. Ma'am, Miss Priya Gavai. Priya is asking. Priya, can you speak?
Yes.
Ma'am, can you speak please?
Yes, I wanted to ask, can a patentee oppose the grant of compulsory license?
Yes. Yes. In the event that see, they come forward, for example, let me take about the Novartis, not Novartis, Bayer Company and Natco Farm. If Natco Farm claimed that yes, they can make it at a very reasonable rate and the similar product or a better quality, even better quality, but they don't meet those standards and they are not working for that, yes, then it can be opposed.
Okay, ma'am. Thank you so much.
You're welcome.
Is there anybody query pending?
Yeah, ma'am, I have one question. I just need to know whether there is any scope for alternative dispute resolution with regard to IPR laws, or should we approach only the regular courts for patent infringement?
Okay, see, ADR is a totally different thing that you have asked, and it has come up recently only. But what our court system or judicial system has suggested is that ADR can be applied in any matter other than the criminal cases. So basically, IPR should also come under that. That is what we understand.
Okay, thank you, ma'am.
Is there anybody? Because ma'am has to leave for other meeting also. So kindly ask your queries faster. So wind up kare ma'am. Okay, Shweta, please, ma'am.
Thank you. Thank you all for joining us today for this informative webinar on WIPO and IPR. I hope that you found this discussion to be both enlightening and engaging. So as we wrap up today's session, I would like to extend a special thank to our panelists for sharing their valuable insights and experience with us. Their expertise and perspectives have enshrined this discussion, and we are grateful for your time and contribution. I would also like to thank and give my express to gratitude to our participants for taking the time to attend this webinar and for your active participation. If anyone needs any law books, please refer the description on the YouTube live. Finally, I invite all of you to stay connected with us and to continue to engage with us on all these important issues. Our organization is committed to promoting and protecting intellectual property rights, and we look forward for continuing this work with all of you towards this goal. Thank you from the bottom of your heart, Ms. Simi ma'am, who supported us throughout this session. And special thanks to KAMRA sir and advocate HIMANSHI ma'am, who organized this webinar. Thank you once again for all your participation and have a great day ahead. Thank you.
One thing more. Next webinar is with Ankita Chauhan ma'am, advocate. She was from Rajasthan. And so next topic was, right now, I'm not telling the next topic because that was a surprise for you and pata lag jayega sabhi ko. So next webinar was on 21 May, Sunday, same timing. So welcome to all of you, and form will be sent to you by mail ID or by WhatsApp. Yeah, Mr. Raj is active. Same sex marriage, yes, right. So okay, everybody, bye and good night and good evening. And thank you so much, Simi ma'am. Thank you so much, Shweta ma'am, and all team members. Thank you so much for cooperation. Okay, guys, take care.